Hello, I'm Nareendra, and today I will be evaluating whether the requirements for formalities detract from the autonomy of landowners in dealing with his or her property. Before I begin, I'd like to give a brief overview of what I'm going to discuss today. Firstly, I'm going to define formalities. Secondly, I'm going to discuss formalities in relation to land law. And finally, I'll be evaluating formality requirements. And then I'll be concluding the whole presentation. According to the Cambridge Dictionary, formalities means something that the law or an official process says must be done. However, as this is a land law presentation, we must look at the legal definition of formalities. Patricia Chrisley states that in law, a formality is a requirement that matters of substance must be put into a particular form. This is to have the intended legal effect. We're trying to understand whether there's an obligation. The courts are moving away from merely looking at the form and studying the substance behind the form. The form is the way the document must be constructed, and the substance is the material within the document. To better understand form and substance, let's look at an example from land law. For a lease to be considered a legal lease, there is both form and substance requirements for the agreement to be considered a legal lease agreement. The document must be in the form of a deed, as stipulated in Section 52 of the LPA 1925. Secondly, it must be in writing following Section 53 of the LPA 1925. Depending on the length of the lease must be registered if the lease is longer than 7 years. This is from Section 27 of the LRA 2002. From the statutory provisions given, we can see that the document must be in a deed form, in writing, and might have to be registered. Following the case of Street of Mumford, we can see that agreement can be considered a legal lease if, first and foremost, the tenant is given exclusive possession. Number two, that the term certainty, and number three, that there's rent payable. These are the substances that should be in the agreement for the agreement to be considered a legal lease agreement. It may be the opinion of some that the form is the formality. However, in the legal field, for the document to have the intended consequence, the substance is of importance, and thus both factors are what creates a legal formality. When examining the history of land law, we can see how formalities affect the rights of an individual. Prior to the Judicature Act of 1875, the King's Court would only give remedies to those who have legal rights, and these rights were given by means of certain formalities. Where there were discrepancies in these formalities, the court would refuse to give relief. However, this was balanced by the Chancellor's Court, where if an equitable right or interest could be proven, a remedy could be given. An equitable right is when formalities are not followed, thus there is no legal right for an individual towards the land in question. After the enactment of the Judicature Act 1875, all courts can hear both cases, but the old system of formalities of common law and the fairness of equity are still followed. Section 1 of LPA 1925 sets out the rights that could be legal. However, these rights are subject to certain formalities. If the formalities are fulfilled, then only then can a legal right be granted. Usually, full formalities must be met in order for legal rights to be awarded, and where there are informalities, it creates equitable rights instead. Section 1 of LPA 1925 only creates legal rights if proper formalities are followed. These formalities have two aspects, which are the document which intends on creating these legal rights must be in the form of a deed. From the case of Eagle Star Insurance Company Limited against Green, it was stated that a deed is something special and not similar to an ordinary contract. A document is not a deed unless it follows the provisions in Section 1 of the LPMPA 1989. Another aspect of formalities is that certain interests must be registered following LRA 2002. A failure to register will lead the interest to be equitable even if there is a deed. The case of HSBC Trust Company against Quinn demonstrates how rigid land law can be at times. In this case, although the document had followed formalities of a deed, due to the wording of the document being unclear, the courts determined that the document was not a deed. The next case is Sharma against Simpson Limited. The courts ruled that because the agreement between the parties lacked formal validity, there was no legal effect to the agreement and it was void. These cases show that even minor non-compliance with formalities required in the dealings with land will amount to the dealings not having the intended legal effect. To counterbalance the rigidness of formalities required, land law has equitable remedies which are available to those with equitable rights. There can be equitable rights when the formalities are not followed. Examples of equitable rights are propriety estoppel, secret trust, and so on. Equity is able to provide remedies where the rigidness of formalities fails to protect the rights of an individual. There is a saying in equity where equity will not permit a statute to be an instrument of a fraud. The next case cited is the case of J.S. Bloor Measham Limited against Colcott, where the courts allowed estoppel to circumvent statutory provisions as long as the relief being sought aligns with the purpose of the legislation. From the case and the quote above, we can understand that equitable rights allow for an injustice to be overcome where the formalities of the law fails to protect individuals and their rights. Proprietary estoppel came into question again in the case of Yalex against Gotts, where the courts concluded that Section 2, Subsection 5, Paragraph C of the LPMPA 1989 made no provisions for constructive trust, but a trust could be created through an estoppel. From these two cases, we can see that although formalities are of importance in land law, the courts are willing to balance the rigidness with the fairness of equity. In order to understand the requirements of formalities, the functions of formalities should be analyzed. There are various functions for legal formalities. However, there are three functions that is usually cited by scholars, which are legal formalities have evidentiary function, it has cautionary function, and finally it has a channeling function. The evidentiary function of formalities is to provide the courts evidence of the contract where there is an argument by the parties in the agreement. Due to the nature of land, which is a physical and tangible asset, there is heavy emphasis by the courts on the need for evidence. This explains why Section 53 of LPA 1925 stipulates that all interests in land must be expressed in writing. This signifies that even Parliament sees the need for evidence in land proceedings and thus makes it mandatory. This is shown in the case of Sharma against Simpsons Limited, where the formal invalidity is that the agreement is in oral form. Thus, the agreement is void. This shows that if the agreement was in writing, following formalities, then maybe the court would have decided differently. The next function of formalities is the cautionary function. Formalities can be used to deter or caution someone from entering into agreement. The function is where the formalities acts as a sort of check against inconsiderate actions. In land law, for example, Section 52 and Section 53 of the LBA 1925 ensures that all conveyancing of land is done in a deed form and in writing. Thus, a landowner or a prospective buyer who intends on buying or selling a property, the deed will lay out the rights of the prospective buyer and notify the landowner of the rights lost due to the sale of the land. Also, formalities usually cause individuals to confer with lawyers, which adds a layer of cautionary function of formalities, where a lawyer who is acting in the best interest of his and her client will warn them if the agreement is not favorable towards them. The last function of formalities is the channeling function. This is where legal formalities is able to channel the intention of the parties of the agreement, and this is shown by the seal. The seal can be a simple and external source to test the enforceability of an agreement. This is especially important in cases of wills, where the main party is absent and unable to speak. The case of Marley against Rawlings demonstrates that the issue that arises when there is a breach in formalities in the case of a will. The court initially, in this case, ruled against the appellant due to the issues in the formalities. However, the Court of Appeal ruled that the will has to be rectified. This case demonstrates that the channeling function of the formalities, where the intention of the party was channeled when the party signed the will, thus his true intentions were later rectified by the court. To truly understand legal formalities and their requirement, the detriment they bring must be analyzed. Formalities, although play a certain function to protect individuals, however creates costs in order to comply with those formalities. Following the Land Charges Act 1972, there's cost to any action involving registering at the land registry. The need to register is stipulated in various provisions. For example, Section 27 of the LRA 2002, a lease longer than 7 years needs to be registered. This formality is an added cost to an individual. If the lease is not registered, then the legal lease protection given to the tenant is not provided. Also, the process of creating a deed and later executing the deed requires a lawyer. The hiring of a lawyer is in order to follow the formalities is another source of cost that is incurred by landowners in order to comply with formalities. Formalities also cause situations that can be seen as unfair or unjust. This follows the case of Petit and Petit, where the concept of a normal married couple having an agreement about their possessions seems absurd. To only rely on formalities to prove legal rights in some instances is unfair. It is especially unfair in situations where it's likely that the agreement was made informally and without legal advice. Thus, a counterbalance to this is obviously equitable rights. It is said that the required formality breaches landowners' private autonomy. This concept is where the law sees private individuals as having the power to affect, inside specific limits, alter their legal relations. This can be further understood by referring to the will theory, where it is said that the law is concerned with the intentions of the promisor, the two parties must be of the same opinion in order to conclude negotiation, any lacuna in the contract must be left, and the courts cannot fill those gaps, and finally, the promisor must be able to change their minds. Analyzing private autonomy and will theory, we are able to understand that it is concerned with the relationship of the individual and the state in a contract, and that the state's presence must be kept at a minimum. The setting of requirements is said to be counter to private autonomy. However, the nature of land, there is a need for the state to step in and ensure that certain protections by means of formalities, even at the cost of landowners' autonomy, is provided. From what was stated earlier, it is understood that legal formalities involve both form and substance of a contract. Next is that in a land law, where all formalities are met, an individual will be able to attain legal rights and protection, and those who fail to follow the rigid formalities will be able to rely on equity to provide fairness and protection. There are three main functions of formalities, which is evidentiary function, it has a cautionary function, and it's a channeling function. With the functions of formalities provided, there are certain detriments that is caused due to requiring landowners and individuals to follow these formalities, which are the cost of complying, and the formalities can be seen as unfair and unjust. Formalities and requiring them affect the private autonomy of an individual and landowners, where their autonomy is limited by the formalities required to be complied with.